Niharika. How are you?
I am good, sir. Thank you.
So, Niharika, will you please introduce yourself and tell us about your family background or family also?
Yes, sir. My name is Niharika Diwan. I have done my schooling from my hometown, Bhiwani, Haryana. Thereafter, I pursued political science honors from Lady Shri Ram College, Delhi University, and I have done my law from Campus Law Center, Delhi University. I belong from a joint family, and we are 20 members living under a roof. All my family is based in Bhiwani, Haryana itself, and engaged in the business like a shop named Karamdeep Brothers, which is a retailing business.
Okay. So, why you want to join judiciary? Straight away, my question. You
Uh,
have done law in which year?
Sir, in the year 2021, I completed my law.
After that, you have persuaded any further studies, or you are preparing for the judiciary?
No, sir, I straight away started preparing for judicial services itself.
Why you want to join judicial services?
Sir, I developed an interest towards judiciary while entering in Campus Law Center as my colleagues and professors encouraged me. And there we also used to witness a lot of honorable justices in our college, where I get to know about this field a little bit. And this field attracted me because of majorly two reasons. One is personal and other is professional. Firstly, being the responsibility and the position that a judge carries, it attracted me. Also, it will provide stability. So these are the two main reasons for my attraction towards this particular field.
Okay. And you are during your student time, you have given your this thing that you were convener of Legal Aid Society
Yes, sir.
and member of Moot Court Society.
Yes,
So,
sir.
what was your experience in that?
Sir, in Campus Law Center, it was great experience. I was engaged in one more court competition, although because of the COVID situation. And regarding the Legal Aid Society, there we used to, there is, I get opportunity to visit juvenile justice vault, also many other central jails like Tihar jail, and many rehabilitation centers also. And I worked there as paralegal volunteer also, where we used to visit slum areas like the Marpur area, and we used to fill different forms for underprivileged people under right to education act for free children below the age of free education for the below the age of 14 years.
You have seen that yesterday Supreme Court commented something on free buys.
Uh, Sir, although I am not aware about it, but aware about that particular judgment of Supreme Court, of Honorable Supreme Court, which uh, in which Supreme Court gave remarks yesterday. But this freebies policy has been matter of contention regarding the Delhi Legislative Assembly elections that I am aware about in general, sir.
Okay. What is your main area of interest in law?
Uh, I am sorry, sir. I think there is some connection issue on my part.
There is some voice breaking also in between sometimes.
Yes, sir. I am sorry, sir. I could not hear your question, sir.
Hello.
Yes, sir. I can hear you, sir.
I was asking you that what is your area of more interest in your law?
Uh, Sir, it is Hindu law and the Indian Evidence Act.
Huh?
Hindu law, sir. It is Hindu law and Indian Evidence Act.
I couldn't follow it. Your voice is not fully audible.
Sir, it is Hindu law.
Okay, Hindu law you are telling.
Yes, sir. And
Okay,
Indian Evidence Act. Yes, sir.
okay. So in evidence, can you tell me what is the primary evidence and what is secondary evidence? What is admissible evidence?
Yes, sir. Sir, primary evidence are those evidences which are perceived by senses and which are primary in nature, and these are the most apt evidences which is accepted by the court. While secondary evidences are those kind of evidences which are which are not original per se, but they have been allowed by court in certain situations which are enumerated under Section 65 of Indian Evidence.
And what is admissible evidence?
Sir, both of these evidences are admissible if court allows, because it is in the discretion of the uh, judge to make any evidence admissible or not admissible on the basis of the relevant facts being duly proved as by the mandate of Section 165 of Indian Evidence Act.
Suppose a person gives some statement in social media, and when the court takes cognizance of the same, and later in the court, the person backs out of it, whether it is permitted?
I am sorry, sir, I could not follow your question because of network issue. Uh, Sir, can
Okay.
you please give me 2
Okay,
minutes so
I'll
that
put my question in another way. Suppose
yes,
a person admits something before the police, and when it comes to the court, he denies the same. What will be admissible? Whether the earlier statement given before the police or the statement which the person makes in the court of law?
uh, sir, I think there is some connection issue, but I was able to hear your question regarding the statement made to police and denied in front of court. So, which
Yeah.
statement would be admissible? I guess that
Yeah.
was the question.
Yeah.
So, sir, regarding your question, statement made to police officer is not admissible and is cannot be proved in court of law. And if further it is retracted by the accused in court of law, so it will not be admissible in court of law because it is not relevant. And even if relevant, it will not be admissible per se because of bar under Section 25 of Indian Evidence Act.
Okay. What about section 498A in the dowry cases? You told you are this thing with the Hindu marriage law. Anything recent, something commented on or happened in that 498A?
Yes, sir. The regarding the misuse of Section 498A and the false cases that has been filed against husband and relatives particularly, the Supreme Court has time and again warned to not to file such frivolous cases against the relatives and has also ordered police officers to first do a preliminary assessment regarding the charges and only then file cases against the relatives and not to arrest people simply on the basis of charges.
Okay. Recently, two suicides have taken place, which was there much in the media on the by the husbands. What is your view
Yes,
on
sir.
that? You know, na, there was recently two suicides committed by the husbands on account of the same excess.
Yes, sir. Regarding the Atul Subhash. Sorry, sir.
And one more was there.
Yes, sir. That happened in Delhi itself. I am
Yeah.
not aware about the name, but uh,
What is your views on that?
Firstly, these incidents are very unfortunate, and uh, this is evident, and the it is evident that harassment and cruelty often occurs against men also, but there is no legislation in India as such right now to cover such cases. Although I believe it is the domain of legislature to bring any such change. And regarding my opinion, sir, court court plays its role regarding such cases by uh, checking the veracity of the facts and providing providing for wives and while balancing between the rights of wives as well as of husband as by not uh, as in the sense that maintenance of wife etc rights of wives can be upheld while not being making these provisions punitive for the husband. So as of now that is the only thing that can be done.
Okay. Do you have any, if a woman claims the cruelty ground for divorce,
Yes, sir.
because it will be very difficult to prove cruelty.
Sorry, sir, I could not follow your question.
I'm saying cruelty is a ground for divorce,
Yes,
though it
sir.
will be difficult for anyone to prove cruelty. So just merely allegation will be sufficient for a ground for divorce.
Sir, mere allegations of cruelty won't be sufficient, and one has to prove cruelty via different evidences, be it
Mm.
mental cruelty or physical cruelty.
Mm.
So same can be proved by variety of evidences. For example, uh, if someone got admitted to a hospital or there are bruises or uh, having some signs of abuse. So all these have to be proved.
Okay. Even after divorce, the woman enjoys the right in the properties of the husband.
Sir, after divorce, the women do not enjoy any such right. But yes, sir, no, sir. No right is enjoyed by
Oh, okay.
women after divorce.
Okay. Okay. Thank you. Saket sir.
Thank you, sir.
Hello, Niharika.
Hello, sir.
Niharika, this is your third attempt at DJS?
Thus, this is my second attempt.
Second attempt.
Yes, sir.
So, as per your own analysis, what went wrong in the last attempt?
Sir, I was not prepared, and when the DGS 2022 came, I was still in my preparatory phase. I started my preparation after college.
So, just for the sake of it, you appeared for
So
the exam.
that was more of a trial test for me. So I was not prepared at all, but I want to see the competition in the DGS. So,
So now you think you are fully prepared?
sir, I believe so.
Okay, all right. Uh, Niharika, what is the meaning of a default bail? Has it undergone any change under the new BNSS?
Yes, sir. Sir, default bail is the bail granted to accused person when he has been in custody for the whole time, uh, for 60 or 90 days, and till the time charge sheet, if charge sheet is not filed. But in the new BNSS, uh, the requirement as regards the police custody in initial CRPC, only 15 days custody was given to the police officer, which were the initial days only. But now this change has been made in BNSS. regarding the requirement of police custody, that now police can take custody in 40 and in first in not sir 40 days anytime in cases where offense is punishable with less than 10 years, and uh, 60 days in cases offense is punishable with 10 or more years. So police can take custody anytime from
All right.
a
Have you
total period
heard?
of 60 or 90 days.
That's okay. Have you heard about one nation, one election?
Yes, sir.
So, from a constitutional law point of view, what repercussions this one nation, one election will have on federalism?
Sir, I am not able to recall right now the exact points. I am sorry, sir.
That's okay. Do you agree with the decision of the Supreme Court in same sex marriage?
Sorry, sir. There was some network issue. I could
Yeah,
not hear the
I'll
question.
repeat myself. Do you agree with the decision of the Supreme Court in same sex marriage?
Uh, Sir, that petition has been still with the High Court for reference and to review its judgment. And sir, I believe the right to LGBTQ people, like right to marry and to have to own property, to have adoption right, these are somewhere the fundamental rights. So if Honorable Supreme Court believes that these rights should be provided to the community of LGBTQ, then yes, sir.
But what is the ratio of the judgment?
Sir, I am not aware about the exact ratio, sir. I am sorry, sir.
Okay, that's okay. That's okay. Niharika, can you explain me the concept of co-parcenary?
Yes, sir.
What is it, and how do we find out whether a particular property is a co-parcenary property or not?
Yes, sir. Sir, co-parcenary refers to the uh, four generations of male members within a Hindu joint family, which forms the co-parcenary, and it has a relation from the concept of Pindadan, that only up to four generation of members can do Pindadan of their ancestors. And so regarding the co-parcenary property, if a family has joint business or working uh, uh, living together or working for a common joint venture, although it may be at various places, at different places, or at a common place, then and there is pooling of resources in that case. So it will be termed as compulsory property, although the intention of the compulsoners would be of pivotal importance in such cases to prove whether a property is compulsory property or not.
Okay. Niharika, can you tell me the ratio in the case of Lalita Kumari versus State of UP?
Yes, sir. Lalita Kumari versus State of UP. In that case, Honorable Supreme Court held that the registration of FIR is deny any person to deny any person to register FIR. So this
So
was
can a police officer say no?
no, sir.
But
They
does he say no?
yes, sir. Practically, yes, sir.
But
These
then what needs to be done then?
uh, sir, the maybe at administrative level, the rules and regulations need to be properly informed to citizens so that they.
No, no. If a police officer is not registering the FIR, then what is the remedy that you have?
Sorry, sir. Sir, in that case, the person, the aggrieved person, can report to the superintendent of police, or it may either go directly to the magistrate to file a complaint, or can file an application before magistrate under section 156(3) of Criminal Procedure Code 1973 to direct the police to report to lodge the FIR and start investigation.
So what will be the difference? So what will be the difference if we go through a normal FIR mode where FIR is registered and the other mode where it is under 156(3)?
In FIR, the police initiates the action by filing the first information report, while in 156(3), the magistrate orders the police, or magistrate has this option to treat that particular application as complaint and to proceed via complaint proceedings. So it is upon magistrate to either treat it as complaint or to direct police officer to lodge FIR.
All right. My final two questions. Second last would be irretrievable breakdown of a marriage. Is it a ground for divorce in India?
Sir, as of now, as per Hindu Marriage Act 1955, it is not a ground, but Honorable Supreme Court has this power to grant divorce on this ground under Article 142 of Constitution of India to do complete justice.
So do you think power under Article 142 can be misused as well?
Sir, it can be misused, but we have to keep faith in our judiciary that it will use this power carefully and to do complete justice itself.
All right. So my last question would be, let's suppose a senior judge tells you to decide a matter in a particular manner, in a particular way. He wants you to give a particular sort of decision. So what are you going to do about it?
Well, in that case, I won't say directly no to the superior officer, but I will calmly tell them that I will surely decide the matter as per the facts and circumstances of the case, and I will do whatever the case will require to do. So I will try to maintain a balance by not directly saying no and to do whatever needs to do in the case.
All right, Niharika. Thank you. Over
Thank
to
you, sir.
Shubham, sir.
Okay, Niharika, how are you?
I am good, sir. Thank you.
Okay, so a lot many questions around law have already been asked. I'll just ask a few. So you have multiple times mentioned about the Hindu Marriage Act 1955, yes?
Sir, sorry, the net got interrupted. I am very sorry, sir.
Completely fine. One of your area of interest is the Hindu Marriage Act or the Hindu law, yes?
Yes, sir. Yes, sir.
So just tell me one thing. What, according to you, is the most important provision of Hindu Marriage Act 1955?
Sir, I think the Section 16 of Hindu Marriage Act, where it has provided legitimacy to the children of void and voidable marriage, so as to prevent the vagrancy and destitution of such children, would be one of the most important provision. And also recently, the Honorable Supreme Court has held that they even have the property rights. So these are the main provisions in the Hindu Marriage Act. Sorry, sir.
State the name of the case.
Sir, it is Revan Sidappa versus Malika Arjun.
Are you sure that is the case?
Yes, sir. This is the case.
Another question from Hindu law. Why do you think a father is not a class 1 heir in terms of succession law?
I am very sorry, sir. The net is again.
Shall I repeat?
Yes, sir.
Why do you think that a father is not a class 1 heir in the succession law?
Sir, earlier under classical Hindu law, since the male members have this privilege of having the personal property as well as property via other means, be it succession skin or other things. So that was the major reason the father was put in the class 2 air. But recently, even Law Commission has made this recommendation that even father and even certain categories are placed in entry 2. So all these entries would be placed in the class 1 airs itself.
Oh, okay. Have you heard about the recent case of Rajneesh versus Neha? Are you aware?
Yes, sir, I have heard about it, but I am not able to recall the exact set of facts.
Okay. Are you aware about the ratio which was provided in the case?
No, sir, I am not aware right now. No, sir, I will read about it.
Okay. One of your area of interest has been Indian Evidence Act, yes?
Yes, sir.
So recently there has been the new criminal laws, and because of which Bharatiya Sakshya Adhiniyam has been inducted, yes?
Yes, sir.
Facing IEA. What is the extent of Bharatiya Sakshya Adhiniyam?
Uh, Sir, actually the net got interrupted. I think you asked something related to the extent of Bharatiya Sakshya Adhiniyam. Sorry, sir, for the inconvenience. Sir, it applies to whole of India. And also, sir, since it is a law of forum, so like various
It uses the term whole of India, Bharatiya Sakshya Adhiniyam.
sir, I am not able to recall it right now, but sir, that is as per my understanding, like which I have understood till now. Uh, but in the Bharatiya Sakshi Adhiniyam, the digital records and etc., even that are made outside India, the applicability of Bharatiya Sakshi Adhiniyam has been extended to even such electronic
Correct.
records also.
So for your knowledge, India word is not used.
Yes, sir. Yes, sir.
Of it, just remember that. Okay,
Yes,
one
sir.
last question from my side. You told that you live under one roof. You guys you have a joint family of 20
Yes,
members
sir.
living under one roof. What do you think is the basic difference between a nuclear family and a joint family, and which one is better? And don't be biased.
Sir, I could not hear the last part of the question. Sorry, sir.
Don't be biased in answering the same. What is the difference between a nuclear family and a joint family? And how does it affect the growth of a child?
Yes, sir. Sir, both set of families have their own pros and cons. Since I am from joint family, so I learned over the period that I do not I am not skeptical of sharing my things, etc., with other people or even to help others or to do work of others per se. But at the same time, I have suffered from some issues like the self confidence, etc., which we usually do not get to develop much in a joint family system. However, in a nuclear family system, since one has so much time to develop that self confidence and but in the nuclear family. However, I believe that as regards the sharing values, caring values, the nuclear family setup may lack at some point of time.
Okay. One last question from my side, Niharika. You said that your family has a shop, they have a proper workspace, they
Yes,
have
sir.
business. Let's say in future, once you become a judge and you're selected as a judge, you got a posting as a judge, one of the parties which come in front of you or which pleads in front of you is somebody known to your own business. What will be your take in that case?
Sir, in that case, because that person is known to like the business because in business there are many people who are known. So I don't think that will create any biasness. But if in any case I will think that that person regarding the decision of that case, I will be biased, yeah, or I could be biased. So I will, in that case, I will accuse myself from hearing such case.
Okay. Thank you so much, Niharik. That is it.
Thank you, sir.